Good morning, anti-sheeple pleaser family. It is M, the anti-sheeple pleaser Mitchell. I am back. I am definitely in the building, filled with energy and joy and love and blessful goodness this Sunday morning. So, with that being said, I want to tell you guys a short story before I play this little article that I found. I had a friend who was telling me about the birth certificate. There was an issue excuse me, that another guy was going through that he knew. And I can't get deep into it, but basically he told them not to sign the baby's birth certificate because they were taking the children away. So the reason why they had the legality to take the children away is because once you sign that birth certificate document, they basically have legality. Your child is property at that point. So when this individual did not sign the birth certificate, they were not able to take the child. So what ended up happening is they gave the mom all types of issues, and she ended up signing the birth certificate for the child. And as soon as she signed that birth certificate, not long after, they came and they took that child. But imagine what would have happened if she never would have signed that birth certificate. So that's something that really led me to investigate this a little further. Like I said, there are two different ploys on this. One side of the story is that, you can trade in your birth certificate because it's worth millions. But when you speak to an attorney or something like that, they'll tell you that, no, that's bullshit. You can't do it or whatever have you. But I felt that the story was interesting. There's actually a little movement going on right now talking about taking back your straw man. But, you guys are more than welcome to listen, investigate yourselves. I'll leave a PDF document also in the description box that will give you a little bit more information on the subject. Unfortunately, I had found this article on the deep web, and it would not allow me to just email it to myself so that I could transfer the link. But you guys can definitely check it out, investigate it for yourself. And like I said, I'll leave a PDF document in the description box. To all my new subscribers, I really appreciate you. To all my day ones, I really appreciate you. Love, blessings, peace, all that good stuff. Other than that, I'll be back a little bit later with some more information on something else that I was requested to do on the video. But peace and blessings, guys. Like you guys know, on the weekends, I'm really busy. I have a lot of stuff to do. So I'm going to be making some pot roast and all that good stuff today. It's time to eat. I can't wait to eat. I had a dream about some pot roast. But anyhow, I will holler at you guys later. I'm out.
By Pam Vredenberg. When your birth certificate was monetized and converted into a United States government bond shortly after your birth by your mother, your net worth became unlimited, into billions of dollars, without your, nor your mother's, and father's, knowledge. When the United States declared bankruptcy in 1933 under the bankruptcy, Strawman, law known as H.J.R. 192, pledged all Americans as collateral, debt slaves, against the national debt to the international bankers, gave all the land to the international bankers, Federal Reserve Corporation, and confiscated and outlawed all the gold except for 1 ounce for each person, thus, eliminating the lawful means, gold and silver coins, by which you could legally pay your debt. The United States also assumed legal responsibility for providing a new way for you to pay. In 1933, the United States government declared that they would pay all of your debts with the money they receive from your labor, birth certificate, and Social Security registered number by what is known as your reserve account worth billions. The United States corporation government did that by providing what is known as the exemption account. The bankers loan credit and not money, because there has not been any lawful money since June 5, 1933. The exemption account is your exemption from having to pay for anything. In practical terms, though, this meant giving each American something to pay with, and that something is your credit. This secret has been hidden for over 79 years. Your value to society was then and is still calculated using actuarial tables. At birth, average value bonds were created from your birth certificate. I understand that this is currently between $1 and $2 million at your birth when your mother unknowingly gave her baby, you, away to the United States government. These birth certificate bonds were collateralized by your birth certificate and your mother's maiden name under an act of Congress in 1921. Then your birth certificate bond became a negotiable instrument just like any security instrument under UCC Article 3, Code of Commercial Law, in which the World Trade falls under. The bonds are hypothecated and traded on the stock market until their value is unlimited for all intents and purposes. People all over the world buy and sell your bond every day over the stock markets as investments. All that credit created is technically, and rightfully, yours. In point of fact, you should be able to go into any store in America and buy anything and everything in sight, telling the clerk to charge it to your exemption account, which is identified by a 9-digit number that you will recognize as your Social Security number, without the dashes. It is your EIN, which stands for Exemption Identification Number from the United States Corporation of America. Take back your Strawman. UCC 1 Uniform Commercial Code. Take back your Strawman. On April 5, 1933, then President Franklin Delano Roosevelt, under Executive Order, issued April 5, 1933, declared, all persons are required to deliver on or before May 1, 1933 all gold coin, gold bullion, and gold certificates now owned by them to a Federal Reserve Bank, branch, or agency, or to any member bank of the Federal Reserve System. James A. Farley, Postmaster General at that time, required each postmaster in the country to post a copy of the executive order in a conspicuous place within each branch of the post office. On the bottom of the posting was the following: criminal penalties for violation of executive order. $10,000 fine, or 10 years imprisonment, or both, as provided in Section 9 of the order. Section 9 of the order reads as follows: whosoever willfully violates any provisions of this executive order or of these regulations or of any rule, regulation, or license issued thereunder may be fined not more than $10,000, or if a natural person, may be imprisoned for not more than 10 years, or both, and any officer, director, or agency of any corporation who knowingly participates in any such violation may be punished by a like fine, imprisonment, or both. Note: stated within a written document received September 17, 1997, from the U.S. Department of Justice, Office of Legal Counsel, Office of the Deputy Assistant Attorney General, Richard L. Schiffen, in response to a Freedom of Information Act, FOIA, was the following. A fact that is frequently overlooked is that executive orders and proclamations of the President normally have no direct effect upon private persons or their property, and instead, normally constitute only directives or instructions to officers or employees of the federal government. The exception is those cases in which the President is expressly authorized or required by laws enacted by the Congress to issue an executive order or proclamation dealing with the legal rights or obligations of members of the public, such as issuance of selective service regulations, establishment of boards to investigate certain labor disputes, and establishment of quotas or fees with respect to certain imports into this country. Note: it seems rather obvious that President Franklin D. Roosevelt was not expressly authorized or required to issue an executive order or proclamation demanding the public, private, to relinquish their privately held gold. The order, proclamation, issued by Roosevelt was an undisciplined act of treason. 2 months after the executive order, on June 5, 1933, the Senate and House of Representatives, 7-3D Congress, First Session, at 4:30 p.m. approve House Joint Resolution, H.J.R. 192, Joint Resolution to suspend the gold standard and abrogate the gold clause, Joint Resolution to assure uniform value to the coins and currencies of the United States. H.J.R. 192 states, in part, that every provision contained in or made with respect to any obligation which purports to give the obliger right to require payment in gold or a particular kind of coin or currency, or in any amount of money of the United States measured thereby, is declared to be against public policy, and no such provision shall be contained in or made with respect to any obligation hereafter incurred. Every obligation, heretofore or hereafter incurred, whether or not any such provisions is contained therein or made with respect thereto, shall be discharged upon payment, dollar for dollar, in any such coin or currency which at the time of payment is legal tender for public and private debts. H.J.R. 192 goes on to state, as used in this resolution, the term obligation means an obligation, including every obligation of and to the United States, excepting currency, payable in money of the United States, and the term coin or currency means coin or currency of the United States, including Federal Reserve notes and circulating notes of Federal Reserve banks and national banking associations. H.J.R. 192 superseded public law. What passes as law today is only color of law, replacing it with public policy. This eliminated our ability to pay our debts, allowing only for their discharge. When we use any commercial paper, checks, drafts, warrants, Federal Reserve notes, etc., and accept it as money, we simply pass the unpaid debt attached to the paper on to others, by way of our purchases and transactions. This unpaid debt, under public policy, now carries a public liability for its collection. In other words, all debt is now public. The United States government, in order to provide necessary goods and services, created a commercial bond, promissory note, by pledging the property, labor, life and body of its citizens, as payment for the debt, bankruptcy. This commercial bond made chattel, property, out of every man, woman and child in the United States. We became nothing more than human resources and collateral for the debt. This was without our knowledge and/or our consent. How? It was done through the filing, registration, of our birth certificates. The United States government, actually the elected and appointed administrators of government, took, and still do, to this day, certified copies of all our birth certificates and placed them in the United States Department of Commerce, as registered securities. These securities, each of which carries an estimated $1 million value, have been, and still are, circulated around the world as collateral for loans, entries on the asset side of ledgers, etc., just like any other security. There's just one problem: we didn't authorize it. The United States is a District of Columbia Corporation. In Volume 20, Corpus Juris Secans 1785, we find the United States government is a foreign corporation with respect to a state. See New York Re. Merriam 36 NE 505, 1441 S 0.1973, 14 L ed 287. Since a corporation is a fictitious person, it cannot speak, see, touch, smell, etc., it cannot, by itself, function in the real world. It needs a conduit, a transmitting utility, a liaison of some sort, to connect the fictional person, and fictional world in which it exists, to the real world. Living people exist in a real world, not a fictional, virtual world. But government does exist in a fictional world, and can only deal directly with other fictional or virtual persons, agencies, states, etc. In order for a fictional person to deal with real people, there must be a connection, a liaison, and a go-between. This can be something as simple as a contract. When both persons, the real and the fictional, agree to the terms of a contract, there is a connection, intercourse, dealings, there is a communication, an exchange. There is business. But there is another way for fictional government to deal with the real man and woman, through the use of a representative, a liaison, and the go-between. Who is this go-between, this liaison that connects fictional government to real men and women? It's a government-created shadow, a fictional man or woman, with the same name as ours. This person was created by using our birth certificates as the MCO, Manufacturer's Certificate of Origin, and the state in which we were born as the port of entry. This gave fictional government a fictional person with whom to deal directly. This person is a strawman. Strawmanius homo, Latin, a man of straw, one of no substance, put forward as bale or surety. This definition comes from Black's Law Dictionary, 6th edition, page 1421. Following the definition of strawmanius homo in Black's, we find the next word, strawman. Strawman, a front, a third party who is put up in name only to take part in a transaction. Nominal party to a transaction, one who acts as an agent for another for the purposes of taking title to real property and executing whatever documents and instruments the principal may direct. Person who purchases property for another to conceal identity of real purchaser or to accomplish some purpose otherwise not allowed. Webster's 9th New Collegiate Dictionary defines the term strawman as 1. A weak or imaginary opposition set up only to be easily confuted. 2. A person set up to serve as a cover for a usually questionable transaction. The strawman can be summed up as an imaginary, passive stand-in for the real participant, a front, a blind, a person regarded as a non-entity. The strawman is a shadow, a go-between. For quite some time a rather large number of people in this country have known that a man or woman's name, written in all caps, or last name first, does not identify real, living people. Taking this one step further, the rules of grammar for the English language have no provisions for the abbreviation of people's names, i.e. initials are not to be used. As an example, John Adam Smith is correct. Anything else is not correct. Not Smith, John Adam, or Smith, John A. or J. Smith or J. A. Smith or John Adam Smith or Smith, John, or any other variation. Nothing, other than John Adam Smith identifies the real, living man. All other appellations identify either a deceased man or a fictitious man, such as a corporation or a strawman. Over the years government, through its public school system, has managed to pull the wool over our eyes and keep us ignorant of some very important facts. Because all facets of the media, print, radio, television, have an ever-increasing influence in our lives, and because media is controlled, with the issuance of licenses, etc., by government and its agencies, we have slowly and systematically been led to believe that any form/appellation of our names is, in fact, still us, as long as the spelling is correct. Wrong. We were never told, with full and open disclosure, what our government officials were planning to do and why. We were never told that government, the United States, was a corporation, a fictitious person. We were never told that government had quietly, almost secretly, created a shadow, a strawman for each and every American, so that government could not only control the people, but also raise an almost unlimited amount of revenue, so it could continue not just to exist, but to grow. We were never told that when government deals with the strawman it is not dealing with real, living, men and women. We were never told, openly and clearly with full disclosure of all the facts, that since June 5, 1933, we have been unable to pay our debts. We were never told that we had been pledged, and our children, and their children, and their children, and on, as collateral, mere chattel, for the debt created by government officials who committed treason in doing so. We were never told that they quietly and cleverly changed the rules, even the game itself, and that the world we perceive as real is in fact fictional and it's all for their benefit. We were never told that the strawman, a fictional person, a creature of the state, is subject to all the codes, statutes, rules, regulations, ordinances, etc. decreed by government, but that we, the real man and woman, are not. We were never told we were being treated as property, as slaves, albeit comfortably for some, while living in the land of the free, and that we could, easily, walk away from the fraud. We were never told we were being abused. There's something else you should know: everything, since June 1933, operates in commerce. Commerce is based on agreement, contract. Government has an implied agreement with the strawman, government's creation, and the strawman is subject to government rule, as we illustrated above. But when we, the real flesh and blood man and woman, step into their process, we become the surety for the fictional strawman. Reality and fiction are reversed. We then become liable for the debts, liabilities and obligations of the strawman, relinquishing our real, protected, character as we stand up for the fictional strawman. So that we can once again place the strawman in the fictional world and ourselves in the real world, with all our shields in place against fictional government, we must send a non-negotiable, private, chargeback and a non-negotiable bill of exchange to the United States Secretary of Treasury, along with a copy of our birth certificate, the evidence, the MCO, of the strawman. By doing this we discharge our portion of the public debt, releasing us, the real man, from the debts, liabilities and obligations of the strawman. Those debts, liabilities and obligations exist in the fictional commercial world of book entries, on computers and or in paper ledgers. It is a world of digits and notes, not of money and substance. Property of the real man once again becomes tax exempt and free from levy, as it must be in accord with HJR 192. Sending the non-negotiable chargeback and bill of exchange accesses our Treasury Direct Account, TDA. What is our TDA? Let's go to Title 26 USC and take a look at Section 163, H, 3, B, 2, $1 million limitation. The aggregate amount treated as acquisition indebtedness for any period shall not exceed $1 million, $500,000 in the case of a married individual filing a separate return. This $1 million, 1 million, account is for the strawman, the fictional person with the name in all caps and / or last name first. It is there for the purpose of making book entries, to move figures, digits from one side of ledgers to the other. Without constant movement a shark will die, and quite ironically, like the shark, there must also be constant movement in commerce, or it too will die. Figures, digits, the entries in ledgers must move from asset side to debit side and back again, or commerce dies. No movement, no commerce. The fictional person of government can only function in a fictional commercial world, one where there is no real money, only fictional funds, mere entries, figures, and digits. A presentment from fictional government from traffic citation to criminal charges is a negative, commercial claim against the strawman. This claim takes place in the commercial, fictional world of government. Digits move from one side of your strawman account to the other, or to a different account. This is today's commerce. In the past we have addressed these claims by fighting them in court, with one legal process or another, and failed. We have played the feudal, legalistic, dog and pony show, a very clever distraction while the commerce game played on. But what if we refused to play dog and pony, and played the commerce game instead? What if we learned how to control the flow and movement of entries, figures, and digits, for our own benefit? Is that possible? And if so, how? How can the real man in the real world function in the fictional world in which the commerce game exists? When in commerce, do as commerce does, use the Uniform Commercial Code, UCC. The UCC-1 financing statement is the one contract in the world that cannot be broken, and it's the foundation of the accepted for value process. The power of this document is awesome. Since the TDA exists for the strawman who, until now, has been controlled by government, we can gain control, and ownership, of the strawman by first activating the TDA and then filing an UCC-1 financing statement. This does two things for us. First, by activating the TDA we gain limited control over the funds in the account. This allows us to also move entries, figures, and digits, for our benefit. Secondly, by properly filing an UCC-1 financing statement we can become the holder in due course of the strawman. This gives us virtual ownership of the government-created entity. So what? What does it all mean? Remember earlier we mentioned that a presentment from government or one of its agents or agencies was a negative commercial claim against the strawman, and the strawman's account, the TDA? Remember we told you entries, figures, and digits moved from one side of the account to the other, or to a different account? Well now, with the strawman under our control, government has no access to the TDA, and they also lose their go-between, their liaison, their connection to the real, living man and woman. From now on, when presented with a claim, presentment, from government, we will agree with it. This removes the controversy, and we will accept it for value. By doing this we remove the negative claim against our account and become the holder in due course of the presentment. As holder in due course you can require the sworn testimony of the presenter of the claim, under penalty of perjury, and request the account be properly adjusted. It's all business, a commercial undertaking, and the basic procedure is not complicated. In fact, it's fairly simple. We just have to remember a few things, like, this is not a legal procedure, we're not playing dog and pony. This is commerce, and we play by the rules of commerce. We accept the claim, become the holder in due course, and challenge whether or not the presenter of the claim has the proper authority, the order, to make the claim, debit our account, in the first place. When they cannot produce the order, they never can, it was never issued, we request the account be properly adjusted, the charge, the claim goes away. If they don't adjust the account, a request is made for the bookkeeping records showing where the funds in question were assigned. This is done by requesting the fiduciary tax estimate and the fiduciary tax return for this claim. Since the claim has been accepted for value and is prepaid, and our TDA account is exempt from levy, the request for the fiduciary tax estimate and the fiduciary tax return is valid because the information is necessary in determining who is delinquent and/or making claims on the account. If there is no record of the fiduciary tax estimate and the fiduciary tax return, we then request the individual tax estimates and individual tax returns to determine if there is any delinquency. If we receive no favorable response to the above requests, we will then file a currency report on the amount claimed/assessed against our account and begin the commercial process that will force them to either do what's required or lose everything they own except for the clothing they are wearing at the time. This is the power of contracts, commerce, and it should be mentioned, at least this one time, that a contract overrides the Constitution, the Bill of Rights, and any other document other than another contract. We should also mention that no process of law color of law under present codes, statutes, rules, regulations, ordinances, etc., can operate upon you, no agent and/or agency of government, including courts, can gain jurisdiction over you, without your consent. We, are not within their fictional commercial venue. The accepted for value process, however, gives us the ability to deal with them through the use of our transmitting utility/go-between, the strawman, and hold them accountable in their own commercial world, for any action, they attempt to take against us. Without a proper order, and now we know they're not in possession of such a document, they must leave us alone, or pay the consequences.